One of the hottest songs out right now is Robin Thicke's Blurred Lines. I know you want it. I know you need. Oh, sorry. Okay. It's serious stuff here.
Exactly. But that song is also under fire, facing allegations of copyright infringement. Ooh. Did Miley's twerking partner steal the music? Sample it? Or create it himself? Here with the insight on this legal battle and others is entertainment attorney Lisa Bonner. Lisa, welcome to the show.
Hi, thank you for having me.
Now, we're having some fun, but this is a serious issue that has caused a lawsuit to ensue, but it's Marvin Gaye's estate claiming that Blurred Lines is too similar to Gaye's song, Got to Give It Up. But if that's the case, why was it Robin Thicke who actually filed the lawsuit?
That's an interesting question. The issue is that Marvin Gaye's estate has been making allegations in the press stating that this sounds a little too much like what we've got in our catalog. So what the artist did is they filed what's called a declaratory judgment, and that is an offensive position, and they're petitioning the court to ask them to declare once and for all that this is not a copyright infringement, this is not a lift, this is not a mimic of anything that is in Marvin Gaye's catalog.
Okay, so it's a preemptive strike.
It is a preemptive strike, exactly.
Sounds like you're just trying to beat them to the punch so they can't get sued.
Right.
Okay.
Well, and if the, I'm sorry, go ahead.
No.
And if the court actually rules in their favor, it's game over, it's done, and they cannot come and seek any kind of copyright infringement. They can't file a suit, and it's finished and it's put to bed.
So who do you think will walk away victorious, the Marvin Gaye family or Robin Thicke?
I think in this instance, I have to say that it sounds a little similar, but it's not so substantially similar in the ears of the listener to really say that this is something that is a lift, it's a sample. I think in this instance we're going to see the judges hopefully rule in the favor because it seems like that they're trying to protect a genre versus this is my song exactly. These are riffs, this is the chord progression, and I think that in this instance, I really do think that it's going to be the artists that prevail.
So how does the judge go about determining who is right or wrong here? Do they bring in a musicologist to listen to the music? Do they just play the samples back to back and see how closely they sound? How does that work?
In this instance, you do have musicologists. If you can read music, you can read notes, but I would dare say in the plaintiff's position in their paperwork that they have actually hired a musicologist who can attest to say this isn't right. I mean, this chord progression, these notes, it's not the same, and you really have to. You can get sued for sampling a very minimal riff or a chord progression, but it's not. The sound is not protectable. Just like an idea is not copyrightable, and you can't protect an idea, you can't protect an overall sound.
Got you.
Yes.
And that's what Robin Thicke was saying. He was just inspired by it.
Exactly, and it's not illegal to be inspired by anything.
That's true.
Okay.
Yeah.
Well, another copyright case that's on the headlines right now is Usher, Run DMC, and Mark Wahlberg are in hot water for allegedly sampling Sylvester Johnson's Different Strokes, but this has been done several times with this song, right?
This is one of those songs, just like a James Brown song, that's always in the news because somebody lifts it's got a real funky chord, real nice music, and in this instance,
look at Lisa jamming it.
I know it.
Funky. Okay.
And I'm just, I think that this is one of the instances where the producer. Perhaps, I don't want to speak out of turn, but they are probably sampling without the permission of the underlying rights holders. In this instance, the master rights holder would be the people that wrote the music, or the master holder, the people that own the actual recording.
Is there a statute of limitations? Because this song was released in 1967.
Right, but the copyright protection goes for the life of the year plus the author in 70 years. And we have, without getting into a lot of the issues that are going on now with the copyright, that's pretty much the basic answer.
Okay, so you can sue for as long as you want, within 70 years.
Yeah, they have a little bit of time left on this one.
Oh, goodness, okay.
Yeah.
Well, what about the time frame from when the song comes out? Because Public Enemy's song, Fight the Power, came out 24 years ago. So how are they able to just now sue them 24 years after it came out? They may not even have money from the songs anymore.
There's no statute of limitations.
Well, there is, but in this instance, this Public Enemy was sued a while ago. So that was put. This is what we're speaking about in terms of how this song is repeatedly sampled. And there was a case at one point when Run DMC was sued for this. A lot of artists have been sued for this. So the Public Enemy may or may not, I believe that case was a while ago. And which just gives rise to the fact that this is something that has a song that is repeatedly sampled.
So if this song is sampled again, the Johnson family still has a right to file suit?
Absolutely.
Okay.
Yep.
And they actually did that with Jay-Z and Kanye, and they settled out of court.
They did.
So do you think they'll follow suit with these newest lawsuits?
Well, I always tell my clients, listen, let's hire the musicologist and let's let the musicologist determine what it is. And if that is the case, you will want to come to a settlement because there are some serious issues where you have copyright statutory protection because it is per use, per sales, per this, and the numbers are astonishing. So if you think that you did it or the musicologist thinks that you did it, I think it's in your best interest to advise your clients to settle, and let's come to a global settlement, give them a portion of the new song's underlying copyright, give them a portion of the royalties, and let's make a settlement and let's move on because you know you weren't right. That was it was not right.
So this could actually be big business for older artists who are being rediscovered by a new generation.
Right, and that's the thing. You know, a lot of the kids they're coming up now, and this is new music to them. I mean, you know, I'm not trying to date us, Lola, but you know, Marvin Gaye. We know Marvin Gaye was, you know, that was somebody.
Never heard of him.
Right? But a lot of these kids are coming up, and they're hearing Parliament Funkadelic. They're hearing Bootsy Collins. They're hearing a lot of all these good things that we used to dance to, and they're like, oh, this is nice. And then they don't have a lawyer telling them. I always tell my clients, do not sample. If you have to,
Now, why is that?
because it is so expensive. And if you insist on sampling, at least, please just do a remake. A replay of the song. Do not sample, because for each, if you sample the music and the lyrics, in this instance, let's say the music, you have to pay the publisher for that.
Wow, now how expensive can it get for sampling?
Listen, it can be, they can say, I want 100% of your song, I want 85% of your song, and it's my song. I can do what I want with it. I can charge you what I want for it. And if it's looped throughout the song, they have a very good argument that they want a large chunk of the new composition.
So it's actually cheaper to do a remake than it is to actually sample a song.
Right,
Who
because
knew? You would think otherwise.
Right, in this instance, because if you use the master and you replay it, you have to clear the master recording rights, and you also have to clear the music publishing. So,
Now,
right.
I've heard some rumors, I don't know if they're true, that you can sample a song if it's only like 5 bars of it or just a very small amount.
No.
No,
You know
it's
how
not
5 bars is not a small amount if you know how to count music. It's not. It's a very large amount, and you can't sample. People have gotten sued for a very, like a riff, a chord progression. And if there are an infinite number of ways to arrange music.
Okay.
And if you insist on arranging it the way someone else has arranged it, and that's a very common misconception, and that is absolutely not the case.
Okay, so what can people do to protect themselves? These music producers that are coming out with these songs. 'Cause I catch myself humming tunes sometime. I don't know where it came from or how I heard it originally. I think it's mine, and then come to find out it was a commercial jingle or something like that. So, is there a way?
Are you a producer? You're a producer. You think it's yours?
In my nighttime.
Nighttime.
I know. So, you know, I think that would probably happen to other music producers. They just hear stuff and they go with it. So, is there a way or system that they can protect themselves from knowing that it's original?
Educate yourself, hire a good lawyer, and I always say once bitten, twice shy, because what happens in these instances, they don't know. They go and the artist chooses a song, and everybody is like, this is fire, this is great, let's use this, and then they go to clear the rights. Someone like me comes in and I start clearing the rights, and I go to the publisher and they're like, we want 85%, we want 90%, we want 50% of the new composition. And guess what? If you're the producer and I'm the artist, that is going to come out of your 50% share. So you might end up walking away with nothing. And then if they want more than 50% share, it starts to come out of the artist share. And then at that point, I start carving up your royalties. Yeah.
Let's talk about Nicki Minaj.
Yes.
Now, she's being sued by a Swedish
Yes.
producing team, New Blue, New Chicago, I'm sorry.
Yeah.
Now, what is this about? It's her song Starships?
Right, and
Okay.
this is, again, another issue of allegedly sampling without clearing the rights.
Okay.
And what is different in this case, you have 2 elements of a copyright in order to, two-prong test to actually state that there is a copyright infringement.
Okay.
In one instance, there is access. Did you have direct access to it, which would be saying, I I used it. I sampled it, which will.i.am did with Chris Brown. You have the other issue of indirect. How did you get this? If this song was not out there, if this song was never released in the United States or it wasn't released commercially on the internet, how did you have access to that? So that's the issue. In the Marvin Gaye case, even in the Different Strokes case, they had access to it. It was an existing
Very
recording.
popular songs.
Absolutely.
Right.
In this instance, it was something that was not existing. And so they're saying, well, how did you get it? And so what the nexus is allegedly that the song was used in a campaign and the producers. So it wasn't Nicki's lyrics herself, it was the producers that she hired, which happens all the time because 90% of the things that happen in these copyright issues is the producer putting in an unauthorized sample.
So where does the blame lie? If it's her producers doing it and she didn't have any knowledge that this was happening, can she still be at fault?
Yes.
Wow.
And then you go ahead and seek indemnification because they're going to come after Nicki because you never heard about the producers. We don't even know who the producers are. Right.
They don't have the money.
Right. The producers actually do. The producers in most instances, and in a lot of instances have more money than the artists, but that's a conversation for another day.
Yeah.
However, right.
True.
In
They
this
all
instance,
do.
yeah, they all do. In this instance, they're coming after Nicki. Nicki has an agreement with them, the producer agreement, whereby I hope that they have asked for indemnification in that agreement and say, if I get sued, I'll defend it, I can bring you in, but then I can go ahead and take the money from those royalties from the producer's side.
Wow.
So the takeaway is don't sample.
The takeaway is do not sample.
Do not sample.
Do not sample. And if you have to, please disclose it early enough so we can take care of business and have this handled properly.
All right. Well, thank you for straightening all that out for us.
Thank you for having me.
Now we know.
All right.
Yes. And you're watching Arise Entertainment 360.